Next topic, differing site conditions. There's one case to talk about here, which is the Renda Marine case. Also, if you pull up the Hypotheticals tab on Blackboard, open that Hypos document, some of this material that I'm referring to here is laid out for you on pages 5 to 6 of Hypos. So the AIA, the American Institute of Architects, A201 General Conditions document, the language for differing site conditions is laid out for you on page 5. And we'll talk about the differences between two different types of DSC claims, type 1 and type 2. And you're going to need to know the difference between those two types. So we know generally differing site conditions are when it turns out during the course of construction that there's something unforeseen, discovered, usually underground or some way hidden, that is going to increase the cost of the construction. And these DSC clauses deal with how those changes of conditions are compensated. As far as type 1 and type 2, they have some similarities. The main difference is that type 1 depends on contract documents, i.e. the plans and specs. And the conditions on site differ materially from information provided by the owner in those contract documents. Whereas type 2 depends not on information provided by the owner, but the condition that is discovered is so unusual that no one could reasonably have expected to find it in that environment. So an example would be you're building something in a desert. No place else in the desert has any submerged rock. You start to excavate on your project and you find a bunch of rock underground. It's the only spot within 100 miles where there's any rock. Something like that, where it's not based on plans and specs, it's just something that's so unusual that you wouldn't expect to find it. A couple of the discussion questions this week ask you to look at hypothetical situations and decide whether type 1 or type 2. And again, this material that's on this slide is also contained on page 6 of the hypotheticals, so if you need that as a reference, it's up there for you. Renda Marine had to do with a contract for dredging the Houston-Galveston Navigation Channel. It's a federal government contract. That's a picture of a dredger on the corner there at the bottom. And Renda Marine had a claim for about $14 million based on differing site conditions. I'm not going to go over the facts too much here, but you'll see the outcome is that Renda lost their claim based on some facts that showed, number one, this wasn't really an unforeseen condition. There was evidence in the record that showed that Renda was reasonably on notice of the conditions that they claimed had increased their cost of performance. There's also a procedural aspect. They blew the appeal time on their claim, so there's a bit of a lawyer malpractice issue in this case as well. So one thing to know about these differing site condition claims is they're very fact specific, and so reading the Renda case will give you a little bit of an idea of how closely the court will look at the facts in order to determine whether it's a valid differing site conditions claim. Moving on, Americans with Disabilities Act. There's two cases you're reading on this topic, both involving Ellerby Beckett, which is a design firm from Minnesota. The Americans with Disabilities Act, passed in 1990, is really, the main goal of it is to improve accessibility to public accommodations for people with disabilities. Just an example, here in Minnesota, this is a picture of the Walker Arts Center in Minneapolis, a very new building. If you've ever been through one of the entrances, this is a flight of brick stairs that greets you when you come into the building from one of the entrances. And this has been criticized by members of the accessibility community for really setting a sort of visual barrier for people in wheelchairs that are trying to use the building. Now, there is an elevator, but it's like, why design a new building with something so inaccessible is one of the main features of the entrance. So this issue comes up with sidewalks too, whether sidewalks are properly accessible by people in wheelchairs, curbs, and also in public transit. There's a continuing wave of litigation across the country about whether different public services are in fact ADA compliant. The cases that you were assigned to read are to do with who is liable for buildings that by design or the design fails to comply with accessibility requirements. There's 2 stadiums, one in each case. The DC case involves the MCI Center. And the issue in both cases is to do with accessible seating and whether people in wheelchairs have equivalent lines of sight to those who are not in wheelchairs. That fact was kind of undisputed in both cases, but they both involved a statutory interpretation issue of whether or not the designer could be legally liable under ADA. In the DC case, the court came to the answer, no, the architect, Ellerby Beckett, couldn't be liable for this non-compliant design under ADA because of the language of the statute in section 302A. Just give you a second to read that. Ellerby's argument on this provision was that they didn't either own or operate the place of the accommodation. And then under section 303, they focused on this subpart 1, which prohibits a failure to design and construct facilities. Ellerby's argument was we didn't design and construct, we only designed. And the court in DC came to the conclusion that meant Ellerby could not be liable and dismissed them from the case. The companion case from the District of Minnesota comes to the opposite conclusion. Basically similar issue, but procedural posture was important. It was brought up on a motion to dismiss. And the Department of Justice also weighed in on this case. So there was some Chevron deference that the court gave. The DOJ joined the side of the plaintiffs, saying that, or was on the plaintiff's side in this case, saying that an architect should be able to be held liable for non-compliant design. And as far as the same argument was put forward in this case about design and construct, Ellerby saying we didn't do both. And Judge Thunheim in this case said it's not appropriate to determine on a motion to dismiss exactly what you did do on the project. And there was certainly evidence in the record that Ellerby was actually involved with the construction phase as well as the design alone. So these 2 cases, neither one, they're both still on the books. This issue about sightlines kind of ran its course. Now buildings that are being designed they're aware of this issue and it doesn't come up anymore. But like I said at the beginning of this section, the issue of owner liability under ADA is still being litigated in transit situations and Department of Transportation litigation. That's the end of my lecture. After you've read the cases and listened to this, there are 5 discussion questions posted under the Discussions tab. And for your participation grade this week, I'm asking you to post something under each of those discussion questions. If you have questions this week, email me. I will try to get back to you. Next week, we're talking about environmental issues, and there are 3 cases in your syllabus for next week. Have a great week.